Exclusive: Onnoghen didn't declare his assets for 27 years as a judicial officer. The Economic and Financial Crimes Commission, EFCC, has accused Walter Onnoghen, the suspended Chief Justice of Nigeria, CJN, of refusing to declare his assets upon his appointment as a judicial officer in 1989. According to the Anti-Graft Commission, there was no evidence that the suspended CJN ever declared his assets until 2016. This was contained in a petition filed by EFCC against Onnoghen before the National Judicial Council, NJC. The petition read, upon his appointment as a judicial officer in 1989 as Justice of the High Court of Cross River State, the respondent is bound to declare his asset. There is no evidence before this honorable panel that the respondent ever declared his asset until 2016 when he filled Annexure E and F of Exhibits R6 and R7. My lords, in Exhibit R7, the respondent admitted that he failed to comply with the constitutional provisions requiring him to declare asset on the ground that he forgot due to pressure of work. My lords, even in the conventional court where rules of evidence is applicable, every admitted facts need no further proof. SSS, 1994, 8NWLR, pt.351, p. 475 and the case of Gov. of Akwa Ibom State v. Janima, 2002, 7NWLR. pt.767, 730 at 778. The agency also accused Onnoghen of depositing the sum of $1,716,000 in a United States dollars account operated with the Standard Chartered Bank in 2009, marked as Exhibit P4C, between 2009 and 2016. According to EFCC, Onnoghen's earnings as a judicial officer could not satisfactorily account for the amount found in the account. The petition continued, from the evidence on record, it is clear that the respondent failed to declare all the accounts and funds in Exhibit P4D when he declared his 2014 asset in November 2016. Your Lordship will observe that the respondent only declared his salary account with the Union Bank Exhibit P3 and failed to declare P4D, which are the accounts that warehoused funds that are far above the respondent's known and provable lawful income. My lords, by the provisions of Rule 1.2 of the Code of Conduct for Judicial Officers, it is clear that because members of the public expect a high standard of conduct from the judge, the respondent is under the obligation to avoid impropriety and the appearance of impropriety in all his activities, both in his professional and private life. It is our submission, my lords, that any conduct of the respondent that give rise to the appearance of impropriety is a judicial misconduct and same is punishable under the Code of Conduct for Judicial Officers. It is our humble submission that the petitioner proved before this honorable panel that the respondent was in possession of funds which are fairly not attributable to his known, provable and legitimate source of income. The evidence shows that my lord earned a monthly salary in the sum of N750,819.87, which is about N9,000,000 per annum. My lords, as shown in Exhibit P10A page 14 paragraph 26, the respondent only earned the sum of N91,962,362.49 as salary between September 2005 and October 2016. It is also on record that the Exhibit P3 is the salary account of my lord wherein his salaries are paid. My lords, The evidence before this honorable committee shows clearly that the respondent opened United States dollars account with the Standard Chartered Bank in 2009, Exhibit P4C. This USD account was opened by Mr. Joe Agasan and the first cash depositor of United States of America dollars into the said account. We humbly refer my lords to the entry of the 29th day of June, 2009. Though the respondent claimed that he was the one who gave the learned San, Joe Aga the $30,000 to deposit to Exhibit P4C, the respondent could not give any reasonable explanation as to source of this money. My lords, the respondent admitted under cross-examination that the USD was not his salary and that he only received dollars as istacodes, which is meant to for his official trips. My lords, upon the opening of the USD account Exhibit P4C, a lot of cash deposits in dollars were made to this account. The evidence before my lords is that between 2009 and 2016 a lot of cash deposits were made into Exhibit P4C. My lords, from the evidence before this honorable panel it is clear that these huge sums of money were not earned by the respondent as his salaries and allowances. It is our humble submission that the burden of proving the legitimate source or origin of the sum of $1,716,000 lies heavily on the respondent. The amounts in the said account were deposited as follows: $74,200, 2009, $291,800, 2010, $340,000, 2011, $625,000, 2012, $298,000, 2013, $40,000, 2015, and $47,000, 2016. The total was $1,716,000. The petition also noted that Onnoghen had attempted to explain the source of the funds, wherein the suspended CJN was quoted to have stated that, "The sources of these are from my savings from my days as foreign student and a successful private legal practitioner, as well as istacodes for annual vacations, medical expenses, international conferences, my earnings as a Justice of the Supreme Court of Gambia." See annexure B referenced as ZD 129/186/01/P. (2/148), among others, conversion of Naira to dollars which some times ago was very favorable. I also have returns from my offshore investments in the foreign currencies which are clearly documented by the bank. I had an overdraft of $500,000 approved for me in the USD dollars account in November 2018. Up till now, the proceeds from the investments are paid into the account as and at when due. My investments with Standard Chartered Bank also include federal government bonds, as can be seen from the records for which I received dividends. However, the EFCC said Onnoghen's explanation was laughable. My lords, the respondent wanted this honorable panel to believe that when he was a foreign student in Ghana he accumulated such amount of money. My lords, how the respondent accumulated money as foreign student was not stated to this panel. My lords, the respondent who purportedly cannot afford to pay N$7,000,000 to Joe Agasan in 2009 wanted this honorable panel to believe that he accumulated dollars to the tune of $1,716,000 in his house. My lords, The respondent, who never declared having $1,716,000 in his asset declaration form as cash in hand, wanted this honorable panel to believe that he accumulated the said sum in his house and only deposited them in the bank between 2009 and 2016 in cash. My lords, the respondent also attempted to suggest to the honorable panel that the $1,716,000 cash deposit in Exhibit P4C was earned by him upon his part-time appointment as Justice of the Supreme Court of Gambia. My lords, this explanation with due respect is laughable in that the respondent was appointed on the 22nd day of November 2012. On the face of the appointment letter, it is clear that the respondent is entitled to the £5,000 sterling, £5,000 sterling, and $20,000 which is payable per session to be determined by the Chief Justice of Gambia in line with the rules of the Supreme Court of Gambia. The respondent failed to show this panel that consequent upon his appointment in November 2012 and the assumption of that office in 2013, the number of sessions he sat as a member of the Supreme Court of Gambia. The respondent also failed to state how much he earned from Gambia, how he was paid, whether cash or through his account. What is clear is that if the respondent is to earn any fee from Gambia, it will be GBP and not USD. What is an issue is the USD paid in Exhibit P4C. The summary of our submission is that the respondent has failed to show with credible evidence how he legitimately earned the sum of $1,716,000, which is far above his lawful and provable income.